everybody, Dana Sparks, broker of Maximum One Greater Atlanta Realtors, and today's contract tip is a revisit or additional information to a topic that we have addressed. And the topic has to do with having a closing attorney acting as the holder of the earnest money. So let's dive in. Earnest money is a very important issue, and the holder of the earnest money has a lot of responsibilities with respect to being holder of the earnest money. So I want to go over again some of the contractual issues to discuss with you when a buyer and a seller do negotiate to have a closing attorney hold the earnest money rather than one of the brokers, either the listing broker or the selling broker. Now, before we dive in, I will let you know that the forms that I'm about to talk about are only forms for the GAR, or Georgia Association of Realtors, contracts. In the RE forms contract and the other contracts, for example, new construction contracts, HUD contracts, so forth and so on, I am not aware of any additional exhibits or forms that are required with those contracts. So if a buyer and a seller do negotiate to have a closing attorney as holder of the earnest money and the parties are binding on under a contract other than a GAR contract, just know that the closing attorney is not obligated to perform any of the functions or responsibilities or duties or have any of the consequences for failing to perform any of those functions as holder of the earnest money, as those duties, responsibilities are outlined in the contract, because the closing attorney does not sign the contract. So I just want to talk about the GAR contract forms that go along with this provision. So the first thing is in the actual purchase and sale agreement. In the GAR, that is form F201 purchase and sale agreement, and in paragraph A5 on the front page of the purchase and sale agreement, where you fill in the blank where it says holder of the earnest money, it clearly states if the holder is a closing attorney, F510 must be attached as an exhibit hereto, and F511 must be signed by the closing attorney. So it's clear when you're filling in that blank that if it is a closing attorney that's holding the earnest money, you must use those other forms, and that one must be attached to the contract as an exhibit, F510, and then the attorney must sign F511. So a couple of other things to take into consideration. I usually save this for the end, but I'm going to start off with this. Regardless of who the holder of the earnest money is, if it is the listing broker, if it is the selling broker, if it is a closing attorney, if it is a third party, if it is the seller, regardless, it is your responsibility as an agent, both as a listing agent as well as the selling agent, to follow up with that earnest money with the holder. Did you receive the funds? Did you deposit the funds? Did you receive the funds? Did you deposit the funds? Did you receive the funds? Did you deposit the funds? That is a responsibility of you as an agent, because there are important consequences if that doesn't happen to the buyer, or for the buyer, for the seller, and for both brokers. So you've got to follow up with that earnest money regardless of who is negotiated to be the holder. Now, let's talk about that form GAR F510, closing attorney acting as the holder of the earnest money. Now, this is an exhibit that must be referenced and attached to the contract, and you must fill this out. So the first thing to take notice of is in paragraph 7, it has a fill in the blank for an alternate holder should the closing attorney not agree to be the holder of the earnest money in the transaction. You cannot leave that blank, and you cannot put in NA. If there's earnest money, there must be somebody that holds the earnest money. So NA is not acceptable. And that form clearly states that the alternate holder must be one of the brokers involved in the transaction. It must be either the listing broker or the selling broker. Now, it also further goes on in this form to explain that the buyer must deliver the entire binding contract, including this exhibit F510, to the closing attorney who is negotiated or is declared to be the holder of the earnest money within 2 business days of the binding agreement. And that is on that form F510, that is paragraph 2. Then it further states in this exhibit as well as in F511. So F511 in GAR is the agreement of the closing attorney acting as the holder of the earnest money. Now, that's not an exhibit to the contract. It's just an agreement that the attorney signs. And the attorney must sign this form, F511, within 3 business days of receiving the binding contract. And that is spelled out in paragraph 3 of the F510 and in paragraph 2 of the F511. So basically, buyer and seller go binding. The buyer is required contractually to get a copy of the binding contract, including the form, to the closing attorney within 2 business days of binding. Then the closing attorney must sign this form F511 within 3 business days after receiving the contract, must sign this form agreeing to be the holder and agreeing to fulfill all those responsibilities. So if the F511 has not been signed within those 3 days, then the alternate holder who was named, which again is either the listing broker or the selling broker, becomes the primary holder. And if earnest money hasn't been remitted, then that alternate holder must send out notices to the buyer and the seller that the buyer is now in default of the contract for not remitting the funds to the holder as the buyer agreed to do. Now, go on and read that form further. If there is a closing attorney as the holder of the earnest money, the form of the earnest money must be in either a wire or an ACH. And we've already addressed this. The closing attorneys in Metro Atlanta do not accept ACHs, the majority of them. So it must be in the form of a wire. So what happens, because a lot of times the closing attorney or the staff at the closing attorney's office, the buyer will come in with a copy of the contract and with the earnest money, but the form of the earnest money that the buyer has is a check, and the closing attorney accepts it. Well, what happens? Well, the buyer's now in default of the contract because on that form F511, it clearly states that the form of the earnest money must be in the form of a wire, and it states it on the F510 also, which is an exhibit. So the question becomes, what do we do at this point? Well, first of all, we know that in the course of events with respect to contracts, an exhibit supersedes the terms of the purchase and sale agreement. So let's say in the purchase and sale agreement, where it talks about the form of the earnest money, which is in paragraph A7, it says earnest money shall be paid by check, cash, or wire transfer. Let's say that on the purchase and sale agreement that the buyer said that the form of the earnest money was going to be a check. However, it clearly states, and that is in paragraph 5 of the exhibit, it clearly states that the earnest money must be sent to the closing attorney acting as holder by wire. Now, we know that since this is an exhibit, the exhibit supersedes the purchase and sale agreement. Therefore, even if on the purchase and sale it said the earnest money was going to be in the form of a check, if you're having the closing attorney as holder, you must use this exhibit. This exhibit says it must be in the form of a wire. So again, back to the original question. What happens when the closing attorney's office signs that form without reading it or for whatever reason and accepts a check rather than a wire? Well, a lot of agents look at that in advance and say, well, my goodness, why can't we just address that as a special stipulation in the purchase and sale agreement? Well, you can't do that. You cannot do that. First of all, it clearly states in Form F511 that the closing attorney, it's in paragraph 2 of F511, it states that the closing attorney shall sign that escrow agreement without modification. So the closing attorney cannot alter that form. It clearly states they can't do that. So again, back to the question, well, why can't you just do a special stipulation, buyer and seller in the purchase and sale agreement, that the form of the earnest money with the closing attorney as holder will be in the form of a check or certified funds or whatever? Well, you cannot do that either, because here's the deal. Who signs the purchase and sale agreement? Yes, the buyer and the seller. Who signs this agreement of the closing attorney to act as holder of the earnest money? The closing attorney. So a buyer and a seller cannot write a special stipulation regarding the actions of a third party who doesn't sign the contract. The closing attorney never signs the contract. So a buyer and a seller can't dictate as a special stipulation what a closing attorney may or may not do with respect to the earnest money. On the other hand, or on the same hand, the buyer and the seller don't sign Form F511. That is only signed by the closing attorney. It must be signed without modification per paragraph 2, and the buyer and the seller don't sign that form. So the closing attorney doesn't sign, the buyer and the seller can't dictate what the closing attorney does, and the closing attorney can't dictate or change the terms because they're not signing the same form. They're not signing the contract, and the closing attorney is not a party to the contract. So you absolutely may not special stipulation that provision out of the contract. If you're going to have a closing attorney as the holder of the earnest money, the form of the earnest money must be a wire. But again, we have this issue with several closing attorneys accepting a check. It's a mess. It's a huge mess. So at that point, then the buyer and the seller must do an amendment, because now the buyer and the seller, because the seller did not agree when the seller signed the contract with that exhibit, the seller agreed that the form of the earnest money was a wire. Well, now you have to get the buyer and the seller in agreement to an action that the closing attorney has already done, i.e. accept the earnest money in the form of a check rather than a wire. So now you have to do an amendment because the seller has to agree that it's okay that the earnest money is in the form of a check, because the closing attorney has already performed an action. So now a buyer and a seller may do an amendment to the contract regarding addressing this issue. And they have to do that because what has happened does not match the terms of the contract. So what do we do? What needs to happen? Well, we have addressed the GAR Forms Committee, and we have contacted Christina Chow, who is the Director of Legal Affairs for GAR. Thank you, Christina, for taking our suggestion. And we have asked that the GAR Forms Committee take a look at these forms. There's a lot of other issues with these forms, but nevertheless, at the very least, to change that provision where the closing attorney may accept a check, whether it be a check from a bank, certified funds, a bank check, or a personal check. That will be up to the Forms Committee to take a look at that, but in addition to a wire or an ACH for the earnest money. We have been told that the GAR Forms Committee is going to address these two forms, the GAR F510 and 511, perhaps not in time for the mid-year review for the 2020 contract forms, but it will definitely be reviewed and hopefully some changes made for the 2021 GAR contract package forms. Now, one more thing to bring up to you, it's more than just a contract issue that needs to be amended. Agents, if you are holding a real estate license issued to you by the state of Georgia, then you also must adhere to license laws. So it is a potential license law violation regarding the form of the earnest money. And it is GREC Rule 520-1-.105C under handling transactions. And what that states is if an agent falsifies or is a party to falsification of a document involved in a real estate transaction or knowingly represents either verbally or in writing to a principal is either the buyer or the seller, or any interested third party, that would be the brokers, as well as the other parties. And the paragraph C states that funds have been tendered in any form other than its true and actual form. So again, in the real estate contract, the exhibit would supersede the purchase and sale agreement. So the exhibit states that the earnest money would be in the form of a wire. So if you know that the buyer is putting in a check for the earnest money, then that the document is different, is indicating is false in essence, indicating a form of the earnest money other than its actual and true form. So again, there are lots and lots of issues involved with the closing attorney acting as holder of the earnest money. A couple of points to remember. Number one, have a conversation with the buyer and the seller and perhaps the co-op agent as to why it is that you are choosing to have a closing attorney act as holder of the earnest money rather than one of the brokers. Additionally, the brokers are held to license laws themselves, where a closing attorney, if a closing attorney doesn't hold a real estate license, doesn't have to adhere to license laws. Now, they can't do anything criminal or illegal with those funds, but there's no recourse for them license law-wise regarding their license to practice. So that's one issue. The other issue is absolutely you may not leave the alternate holder blank. You need to fill in either the listing or the selling broker. Another issue is, why is it that you want the closing attorney to hold the earnest money? Closing attorneys are awesome at closing transactions, but they're not necessarily great holders of earnest money, whereas brokers deal with earnest money issues all the time, and the brokers are very well versed in the purchase and sale agreements in a different level than a closing attorney is, as well as having recourse against their personal license, their firm's license, and the company's license if there is something amiss with respect to handling earnest money. Another issue to consider is there are a lot of closing attorneys that will not accept earnest money in any form if it's under a certain amount. So depending on the amount of the earnest money in a purchase and sale agreement, closing attorney may not agree to hold it regardless. So these are all issues to consider when you are negotiating a contract and the buyer and the seller or even a co-op agent bring up the issue of a closing attorney as the holder of the earnest money. Again, bottom line, as an agent, you are responsible for the handling of earnest money, and you have got to follow up with the holder. Again, if it's a closing attorney or one of the brokers, did you receive the funds? Did you deposit the funds? Did you receive the funds? Did you deposit the funds? You've got to do that on behalf of yourself as a licensee, your broker, and the buyer and the seller. So please read through these forms carefully. We are excited to see how GAR addresses these forms moving forward. And I hope this contract tip helped you out. Thank you guys so much for watching. Dana Sparks, broker of Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education.